Hello, today I would like to discuss a very interesting topic. We call it procedural fairness, and the term itself is not very familiar with general public because it's more related to processing of applications in progress when both sides are supposed to provide opportunity for each other to express their opinion and information and data, and decision makers in terms of IRCC processing officers generally required to follow the rules of procedural fairness throughout the whole decision-making process. What is related to? Well, procedural fairness generally required that applicants provided opportunity and fair and unbiased assessment of the application. Doesn't matter what application we're talking about, permanent residency or temporary residency, they all fall under this category. Be informed, applicants must be informed of the decision makers' concerns. And that's why sometimes we receive refusals and people say, well, that's what I got. And my first question, did you receive a procedural fairness letter if it was a PR application, or did you receive any following up updates from IRCC in terms of your application and process? If not, then we can claim that procedural fairness principles weren't followed. The last on general list of those principles of procedural fairness, applicants must have a meaningful opportunity to provide response to concerns. It means if, for example, somebody asking for something complicated to be added to application, they cannot be in the right state of mind given like 3 days deadline. It must be reasonable and meaningful so people actually can get what they ask. And in any case, we try to jump in on that kind of inquiries right away and protect our clients from unfair treatment, and definitely following closely on procedural fairness and trying to create environment for the client when they actually have the right for this fair and impartial decision-making process. Well, examples of different situation of biases can vary actually from territorial, sometimes racial, sometimes political biases, and it leads to the matter of officers making decision, judging on this decision before it's fully unfolded in front of the officer, like jumping into conclusions, we call it, right? Or prejudicial when attitude, let's say, when, like I mentioned, we have situations when somebody experiences prejudice. It's not that rare, unfortunately, when federal court discuss situation and officer, for example, we have those examples on political motivation front or on same-sex marriage, for example, when sometimes officers very prejudiced about that due to various personal reasons and beliefs. Previous involvement in the case can play the role. That's why, by the way, when we asking for reevaluation or a reassessment of application at hands, we definitely insist that not the same officer is reviewing what happened and what we complain about. And last but not least, of course, considering this is a small word, some people call it a conflict of interest, but obviously that's a violation of procedural fairness and definitely bias if a relationship between decision maker and one of the interested parties exists. And sometimes it can fall under financial relationship or personal relative, personal relationship when people are relatives, for example. So that sort of thing definitely fall into category. A right to be heard is a little bit different. It's more complicated due to unfamiliarity of people with judicial process itself. But definitely we're talking about a situation when decision maker is not extending search for documentation or evidences provided, and they basically under obligation to advise the applicant of any kind of source materials or any kind of information that may lead to fair representation of the client. And definitely, for example, certain things we have to consider as we call it special circumstances, but basically certain things we need to be careful about, because we as service providers and acting on behalf of the client cannot experience bias. Also, because we cannot say, for example, that, well, we please provide the officer who is of certain religion or certain beliefs. Of course, we cannot say that, because that would be bias from our side, right? Sometimes people actually confuse about that. And I always say this to client: please be fair, please be reasonably unbiased, and try to present your open mind to the process. And the most interesting part of this, and to conclude, I can tell you that procedural fairness letter, that's what known to people sometimes in the process when they receive it and they asking us what it means. Well, this is your chance to basically exercise your right of procedural fairness. And if you receive a letter of procedural fairness, or PFL, we call it procedural fairness letter, definitely you have to act fast, and it's a chance for you to present new materials if something unclear or you missed the chance to present it. And mostly it happens during permanent residency applications, when we're dealing with, for example, startup visa program, or regular application for provincial nominee program, for example, or sponsorship, family sponsorship. Very few actually, if applying themselves, know the process, know the amount of information supposed to be provided. And it's not that uncommon that IRCC responding with PFL, procedural fairness letter, and demanding more materials. So all in all, that's why, technically speaking, you need representative. Subscribe to our channel for more advisories. Like this video, share it with those who you might think may benefit from this, and definitely we wish you all the best and stay safe.